the duty of practitioners and users to ensure that the standards of practice of arbitration in Nigeria is at par with international best practices. Despite these challenges, the use of arbitration as a means of resolution of disputes has been on the rise in Nigeria, and Nigeria is emerging as a major player, not only in domestic arbitration, but also in international field. The writing of this book could not have come at a better time. This book is not only a call to action, it is a roadmap for reforms. As the world continues to come to terms with the effect of the COVID-19 pandemic, the book will serve as a guide to policymakers, practitioners, and users to identify crucial areas for reforms in the recognition and enforcement of foreign international commercial arbitral awards. Once again, on behalf of all the members of the Chartered Institute of Arbitrators, I congratulate the author of this book, Mrs. Chinwe Odigwegu, Fellow of the Chartered Institute, for the excellent work on the book. I also wish her a very happy 40th birthday, while I urge us all to order the book, as this will be a rich addition to our libraries. Thank you very much for listening to me. Thank you and congratulations, Chinwe.
Thank you so much, my president. Thank you so much, sir.
All right, then, thank you very much. I hope everyone can hear me now.
Yes,
oh, thank you very much. Thank you very much. Apologies for the technical issues. I'm actually originally billed to be the compere at this event, and I really appreciate everyone for finding time to celebrate with the author and our sister. Thank you very much once again. Your Excellencies, your Lordships, learned silks, distinguished guests, ladies and gentlemen, please permit me to invite you, with all modesty in me, to this intellectual dance of the mind. Now, ladies and gentlemen, we'll go straight into the book review, and I have the singular honor and pleasure of inviting to the microphone Mrs. Abimbola Keredolu SAN. She's a partner in the law firm of Banwa and Igudalo for our book review. Thank you very much. Ms. Keredolu, please.
Thank you very much. I want to first wish the writer, the author of today, Chinwe Odigwegu, many happy returns, long life and prosperity. And thank you for the privilege and honor of inviting me to review the book. Without much ado, I shall launch into the review. It's my honor to review the book titled Recognition and Enforcement of Foreign International Commercial Arbitration Awards, the Nigerian Situation, Challenges and Proposed Solutions, written by Mrs. Chinwe Odigwegu. Chinwe Odigwegu is a multi-talented lawyer, mediator, arbitrator, mediation advocate, trainer, and notary public from Nigeria, Notary Public for Nigeria, a proud mother, and a very devoted wife. She has many years of experience in legal practice, and not as many years as senior in-house counsel, but cumulatively, between legal practice and in-house work, she has many years of experience. And it is by virtue of all of that experience, and especially her experience in the practice of arbitration. She also has extensive experience in mediation, but her experience in arbitration, no doubt, is what has birthed the treatise, the book that we are going to be looking at today. As the title suggests, the book is about the experience of a party who either won or lost an arbitral award from arbitral proceedings which took place outside of Nigeria. But now seeks to enforce or urge the court to refuse the enforcement of such award in Nigeria. The book is divided into 5 well laid out chapters. The first chapter looks into the current status of various laws, procedures, and legal instruments that regulate the recognition and enforcement of foreign international awards in Nigeria. It provides all of the background, introduces the topic, and gives all of the background that has led the author to meet a need to address what, to a large extent, because it has generated a lot of literature, to resolve the conundrum that has come to play in the field of recognition and enforcement of foreign international commercial awards. The second chapter of the book deals with the different legal instruments and procedures for recognizing and enforcing a foreign international commercial award in Nigeria. It looks at the legal instruments for enforcement, the procedures, and deals with each one by way of a thorough analysis. The third chapter digs into the challenges experienced in the recognition and enforcement of foreign international commercial arbitration awards in Nigeria. It goes further to explore whether the applicable legal instruments and procedures provide an effective framework for enforcement of foreign international commercial arbitration awards. The third chapter looks at the challenges that parties experience in the recognition and enforcement of foreign international commercial awards in Nigeria from a stakeholder's perspective, and looks at the different factors that could influence or affect the recognition and enforcement of foreign international commercial arbitration awards one way or another. In the third chapter, the author examines the applicable legal instruments and procedures and delves into the question whether they provide an effective framework for enforcement. The chapter also looks at the attitude and reaction of the Nigerian courts to examine whether they actually understand the objectives of arbitration and their roles in ensuring that the objectives of arbitration is achieved. The author goes further to look into time factor. Under the subject of time factor, the author looks at a very relevant issue, which is the limitation period. And this has generated a lot of debate based on case law, Supreme Court decisions that have been a bit at odds with what we believe to be the reality. So the limitation period for enforcement is examined. The author examines the slow court system, the length of time it takes to argue and conclude an enforcement matter or a refusal or an application to refuse to recognize an award. It looks at, the author also examines the issue of the allegation of corruption that is inherent in our system. And this is topical these days. The author examines the legislative and procedural ambiguities and the gaps, which she calls lacuna, gaps, empty spaces in the law which are all affecting the effectiveness and speed with which foreign international commercial arbitration awards are enforced or recognized in Nigeria. The author examines the issue from the perspective of the contracting parties, who are the investors, the business owners, and their counsel, and asks a deep question whether these parties are part of the problem that militates against the expeditious enforcement or recognition of foreign international commercial arbitration awards in Nigeria. And she identified that a lack of understanding and objectives of arbitration is one of the contributory factors to the problems or the challenges that are being experienced in the Nigerian industry in this regard. She examines whether the arbitral institutions, the arbitration institutions, the professional bodies, and she looks into the question whether they matter in the subject at hand and whether they contribute to the challenges being experienced in that space. In the fourth chapter, the author proposes solutions to the challenges being experienced in the area of recognition and enforcement of foreign international commercial arbitration awards. She examines the UK, what obtains in the UK as a model. Laws and rules. Limitation period, again, she examines. The competent court for enforcement, grounds for refusal. And she examines the thought that perhaps the right of appeal should be restricted. She examines the proposal whether the establishment of specialized or commercial courts would assist in resolving the problem. She actually recommends it. And she then proposes the training of judges to better understand the objectives of arbitration, so that if they understood the objectives of arbitration better, their application, their dealing with such matters, their orientation in dealing with arbitration matters would assume a different perspective for the better good of recognition and enforcement of such awards in Nigeria. She examines the issue of progressive judicial support. She examines the much touted issue of purging the judiciary. She proposes and looks into the issue of Nigeria having a digital court system, and then the training of legal practitioners, in-house counsel, business owners, parties, general training, with the view that perhaps the training would lead to a reorientation for the advancement and promotion and effectiveness of enforcement of such awards in Nigeria. She looks into whether sanctions against legal practitioners would resolve the issue. And then she also recommends that government's attitude in this regard should also change. And in the final chapter, she discusses the future of Nigeria as an enforcing state in international commercial arbitration. She proposes and explores the real issue in question, the problems, the proposed solutions. She analyzes the proposed solutions in view of current realities, and then she makes recommendations. Having gone through the book, like I said, it was a great honor and pleasure to read the book. I will not be doing justice if I do not highlight the drawbacks for me. And I'm glad she's smiling because she knows I will not let her off lightly on this. And reading through the book, honestly, it was a very interesting read. I actually, any book I put beside my pillow must be a good book. If you find the book beside my pillow, it's good. I kept coming back to it until I finished it. However, like I identified that in a certain area, and I will not spoil it for people, I would want people to read and perhaps agree or disagree with me on this. She went into a very interesting topic that I was actually interested in. And I really dug in and said, wow, yes, this is it. And she had itemized a number of things that I thought she would discuss. Well, she discussed a few of them and left me high and dry. I have said to the author that she should consider writing a second edition and doing justice to the itemized area to which I have referred. It will, funny enough, that was the first time I had seen, I'd heard of the principles, but that was the first time I had seen an articulation of all of them as the author listed them. So I was digging in to enjoy the education that she would provide. But unfortunately, she just touched on briefly on the ones that she felt were important to her discourse and left me high and dry. So I hope the author will consider doing a second edition where she will do justice to the articulation of those principles. Because in the beginning of the book, she explains very beautifully, lucid language, and entices you into reading more, entices you to want to know more. And then there was what I would call an anticlimax. Aside from that, I recommend the recognition and enforcement of foreign international commercial arbitration awards, the Nigerian situation, challenges and proposed solutions, written by Mrs. Chinweaku Odigbuegu. I highly recommend it. I thank you for listening. I hope I'm being heard.
Thank you very much, Mrs.
Some years, Wally, apologies.
Sorry,
Mrs. Akeredu, I worked with Mrs. Akeredu for some years at Bama Igodalo. It was such a lot of learnings and everything. Thank you very much, ma'am. Thank you so much.
Pleasure. Thank you.
Okay, then. Thank you very much, Mrs. Akeredu, SAN. Thank you very much, Leonard Silk, for that beautiful review. We continue to learn from you every day. And of course, we take your recommendations very seriously. Everybody should go out there, ensure that you all get a copy, at least a copy of the book, and please find out those salient points that the Leonard Silk was really stressing on. I'm very sure it will be a good read, and this is to encourage and recommend once again to everyone that please get at least a copy of the book. Thank you very much. Your Excellencies, distinguished guests, ladies and gentlemen, we're going straight to a fantastic time. I guarantee you, because we have an array of distinguished personalities who are going to be doing justice to the topic of the day. The panel is going to be focusing on international arbitration, Nigeria as an enforcing state, and I have the singular honor of introducing you all to the world of our panelists. The first panelist for today is our one and only Mrs. Funke Adekoya, Senior Advocate of Nigeria. She's a partner in the law firm of Alex, and I would like to just introduce her very briefly. Mrs. Adekoya is a founding partner at Alex and heads the Dispute Resolution Practice Group of the law firm. She was appointed Notary Public in 1986 and elevated to the rank of Senior Advocate of Nigeria in 2001. She has over 45 years experience in litigation and arbitration. And of course, in the field of arbitration, she represents both local and transactional parties as counsel in domestic and international arbitration proceedings within Nigeria and abroad, and has acted in numerous disputes as either party appointed arbitrator, sole arbitrator, or presiding arbitrator. She lectures regularly on arbitration law and procedure and has been approved, I beg your pardon, by the Chartered Institute of Arbitrators as a tutor at the associate to fellowship course level. Ladies and gentlemen, among our several accolades, our thought leader in arbitration, Uzu Legal, and most outstanding female legal practitioner, Women Entrepreneurs Africa Network of the Year in 2007. Please welcome our one and only distinguished erudite Mrs. Ficaa of Nigeria. I also would like to introduce the second member of the panel, Dr. K.U.K. Kweme. Dr. Kweme is a partner in the law firm of Olaniwon Ajayi LP. Is a partner in the dispute resolution practice of the law firm. He's a former student of the Hague Academy of International Law and visiting researcher at the Harvard Law School. He specializes in international economic law and international dispute resolution, international commercial arbitration, public interest litigation, and white-collar crime prosecution. Dr. Kweme is a visiting scholar at Harvard University and Cambridge, Massachusetts, and holds a PhD from the University of Hamburg, Hague Academy of International Law, Hamburg University School of Law. Dr. Kweme is absolutely and incredibly fluent in German. Please make welcome Dr. Kweme once again. Thank you very much, sir. And our third panelist for the day is our own Mr. Uche Uweche. He's the company secretary and director of legal at GlaxoSmithKline, Nigeria. It gives me great pleasure to introduce him to you all. He joined GSK as legal manager in 2006 and was later appointed company secretary and legal director for GSK entities in Nigeria and other Anglophone West African region in 2010. Mr. Uweche, prior to GSK, worked as the general counsel and company secretary of the defunct Gulf Bank of Nigeria PLC and had engaged extensively in legal practice with George Etomi and partners. Please make welcome Mr. Uche Uweche. Please put your hands together for him if you can. Thank you very much. And of course, to lead the panel, to moderate the panel, I beg your pardon, is our own Mrs. Deborah Chukwedo. Please permit me to introduce you all to Mrs. Chukwedo. She is a partner at Acedo Law, and she heads the company secretarial, corporate, commercial, and real estate practice group. She's experienced in the practice, documentation, negotiation, and dispute resolution aspects of real estate law, commercial, capital markets, and security matters, and has extensive practice in advising clients on corporate and commercial matters, including acquisition and disposal of businesses, group reorganizations, corporate restructuring, mergers and acquisition, mergers, joint ventures, and general corporate advisory. Ladies and gentlemen, your excellencies, Leonard Silks, please permit me to now hand over these proceedings of the panel session and panel discussion to Mrs. Deborah Chukwedo. Thank you very much.
Thank you, Wale. Good afternoon, everyone. So we'll just dive right into the panel discussions. One of the advantages of arbitration as a dispute resolution mechanism, especially in Nigeria, where the dockets are overflowing with cases, is that the parties get to choose the arbiter of their dispute from outside the court system. Armed with an award, however, a successful party must resort to the courts for enforcement of their awards. So on this panel, we'll be discussing some of the factors that affect the effective enforcement of arbitral awards in Nigeria. So I'll begin with the Leonard Silk, Mrs. Adekoya. On page 14, subparagraph 3 of the book, Chinwe writes, and I read, "It is a fact that arbitration has to be effective for contracting parties to experience its benefits. In this regard," she continues, "an arbitration award remains worthless until it is enforced." On page 37, she speaks of the Chartered Institute of Arbitrators UK London Centenary Principles, which was launched in 2015, pursuant to the London Centenary Conference, to mark the Institute's 100th anniversary. The 10 principles were described as a draft set of principles for an effective and efficient seat in international arbitration. The second principle speaks of an independent judiciary, competent, efficient, with expertise in international commercial arbitration and respect of the parties' choice of arbitration as their method for settlement of their disputes. So Leonard Silk, in the light of this second principle and considering your experience both domestically and internationally in commercial arbitration, what is your opinion on the disposition of the Nigerian courts regarding enforcement of arbitral awards?
I think that the Nigerian courts still have a way to go to fulfill the requirements of the second principle. The idea of the centenary principles of the Chartered Institute is that any nation that fulfills those 10 principles would be considered as a safe seat for international arbitration. For us, our judiciary still needs more training, more exposure, and a greater understanding of the relationship between the arbitration process and the judicial system. They are to enforce or to set aside an award based on the limited scope provided in the Arbitration Act or in the relevant legislation. They are not to open up the award, and they are not to review or second guess the decision of the arbitrators, which are things that I see in some of the decisions. So they have a way to go. You're muted, Deborah.
Okay, thank you, Mr. Adekoya. Mr. Owecha, in your opinion and from your experience, how do disputes and delays in the court system affect business operations?
Thank you, Deborah. I think it's very thought-provoking from the point of view that businesses are not in business to go to court. And I think it's a role that as lawyers, in-house counsel, we need to emphasize over and over. Unless your business is a law firm, in which case you trade in disputes, you provide services in dispute resolution. Companies generally are set up for economic purposes to maximize profit. Therefore, as much as possible, mitigating from the word go against disputes, I think is a very critical role that as in-house lawyers we should always bear in mind. However, we know it's inevitable where you have people doing business based on different philosophy, especially in a country like Nigeria, where you can hardly do any serious business without having to engage with third parties from outside the country. So you find a situation where you are importing part of the products from Germany, part from India, part of the raw material from China, packaging from Thailand. So it then becomes necessary that you anticipate that disputes will arise. And I think that when you anticipate that, obviously, there have been issues where parties are at loggerhead as to which jurisdiction should apply. I think those are the circumstances where you choose more or less a neutral law, which is usually the UK, and arbitration is often the preferred option. So I think arbitration simplicity offers businesses sort of a controlled dispute resolution environment that involves certainty around cost, around a collaborative, clear alternative that you can go to arbitration and still come back and continue to do business. Then, of course, you want confidentiality around your commercial transactions with third parties. And then, of course, you want a competitive advantage. You want to be able to keep your secret on how you operate. So clearly, those are some of the issues that as a business, you always need to consider when you're entering into transaction and you are considering how those disputes will be resolved. How the issue under discussion helps us to arrive at a very good point is one that we should think about. I think to Chinwe's credit, she has actually open this very important area for conversation so that not only does the book act as a reference point, but I think it enables us to even think. And I think Mr. Akredole said, and I referred to that, this is a very good conversation that will then take us to where we ought to be. So I think arbitration, in summary, of course, offers a very good opportunity for businesses to control dispute resolution risk. And to be clear, I've always adopted it in the companies I work for, including GSK. Thank you.
Thank you, Mr. Weche. Dr. Kweme. So Mr. Weche has made a comment about mitigation of disputes regarding costs. And the ACA bill has made strides in ensuring that the ACA is more compatible with modern arbitration laws. An example, the removal of the ground of misconduct. So my question to you is, in order to make sure that costs are mitigated, to ensure that Nigeria is more desirable and cost efficient to choose as a seat of arbitration, where a Nigerian company has an award procured in a foreign state and wants to apply to enforce or set aside that award in Nigeria, can this application be done? Can this application be made in Nigeria, even though the seat was a foreign seat?
Thank you very much, Deborah. The starting point for me is to agree with Uwechi that sometimes it will be desirable to make Nigeria the seat of arbitration, especially when the dispute is subject to Nigerian law and the arbitration is between Nigerian parties for various reasons. I mean, we have a world-class arbitrators that can handle any commercial disputes. We have a good, arbitration institutions. And also this will save the parties the huge cost of travel and sundry expenses. The disputes, can also be handled by arbitrators that studied Nigerian law and have experience in our local circumstances. In addition, it will be easier for in-house counsel to make the right choices relating to the arbitration. I also agree with Mr. Dekoya that we are not yet there, in relation to being a safe place for arbitration. But as a destination for arbitration, our courts, I believe, have moved from what I call judicial hostility to judicial hospitality. And I believe, I also agree that if the removal of the ground of misconduct is removed, it will help in reducing the number of cases that go to courts after an arbitral award. But I consider the second leg of your question very interesting, because I take the view that the highly, widely held view that an international commercial arbitral award can only be set aside in the country of the seat of arbitration is wrong. In Limac versus Kaduna Electricity Distribution Company, the Lagos, I beg your pardon, the High Court of the Federal Capital Territory on the 17th of July set aside an ICC award pursuant to an agreement with Turkey as the seat of arbitration. And by the provision of section 52 subsection 1 and section 52A Roman figure 8 of the Arbitration and Conciliation Act, the Nigerian company, in the hypothetical case that you painted, can validly apply to set aside an award made in a foreign seat if the company can show that the parties to the contract which gave rise to the award chose Nigeria as the governing law of the contract. This is because of the combined reading. On the combined reading of section 52 subsection 1 and section 52A Roman figure 8, any of the parties to the arbitration agreement may request the court to refuse the recognition and enforcement of an international commercial arbitral award if the award has been set aside or suspended by a court in which or under which law the award was made. And recently, the U.S. Court of Appeals for the District of Columbia has confirmed this point in a decision delivered on the 19th of June 2020. In the case of PNID and Federal Republic of Nigeria, I will quote what the U.S. Court of Appeal of the District of Columbia said. Quote, PNID responds that the High Court of Nigeria did not have the supervisory jurisdiction over the arbitration and thus could not permissibly set aside the award because the parties had agreed to arbitrate in London. We are not so sure. As noted, the New York Convention recognizes that an award may be set aside or suspended by the courts of the sovereign whose substantive law governs the arbitration, as well as the courts of the sovereign where the arbitration took place. Here, the rule would seem to include the courts of Nigeria. You would recall in the PNID arbitration following the liability award, the Federal High Court set aside the liability award. And the arbitral tribunal in the PNID versus Federal Republic of Nigeria proceeded to the remedy stage of the arbitration and then awarded remedies against Nigeria. So the US Supreme Court was making it abundantly, I beg your pardon, the US Court of Appeals was making it abundantly clear that it's permissible for a court in the country whose substantive law governs the arbitration to set aside an arbitral award. Thank you very much.
Thank you, Dr. Kweme. Mr. Oweche, can I come back to you? Hello, Mr. Oweche.
Yes.
From a business point of view, can you describe Nigeria as an arbitration enforcing state?
Just to be sure. It's a question that there's no clear answer. I'll put it this way. We are on a journey. We haven't gotten there. Clearly, I still believe that policy statements, clarity around the rules, taking a look at the laws that are applicable, if you look at the 1922 Act, as well as the 1961, and then the Arbitration and Conciliation Act, I think 1988. Just like KAMA, we have moved. There needs to be a consensus around what we want with respect to arbitration. If I may recollect, during the pre-panel discussions yesterday, the issue around litigator versus arbitrator mindset is something that is a cultural issue. It appears that we want to fight. Our culture encourages fight until the last man standing, which in my view is antithetical to the very essence of arbitration, which is to find a non-adversarial method of resolving disputes that could still enable parties to continue to do business. Until we cross these milestones, I think ours is still a work in progress. That's really my view.
Thank you, Mr. Oweche. So basically, the arbitrators need more training, and arbitrators, when they cross over to arbitration, need also avoid the adversarial mindset. Thank you. Dr. Kweme, I'll come back to you, please.
Thank you.
Under section 57.1 of the AC, the court is defined to mean the High Court of the State, the High Court of the Federal Capital Territory Abuja, or the Federal High Court. There has, however, been some controversy as to which court to approach for enforcement of an award. How do you determine the applicable court?
Well, thank you, Deborah. I am not aware of a direct authority of the Supreme Court or Court of Appeal on this point, but I am aware of the decision of the Federal High Courts on the point, precisely in the case of a AFCON Nigeria Limited and registered trustees of Ikoyi Club. The Lagos State High Court, the Federal High Court held that the Arbitration and Conciliation Act, does not confer additional jurisdiction on the Federal High Court or the state High Court or the High Court of the Federal Capital Territory, and that in determining which of those courts have the jurisdiction to entertain an application relating to the enforcement of setting aside an award, that reference has to be made, to the Constitution regarding the court with the original jurisdiction to determine the matter that gave rise to the award. And recently, I was part of a case which I think endorses that proposition, that decision, precisely in the case of Access Bank versus Arestus Akimbola. Although this case concerned the enforcement of a foreign judgment, that is precisely the judgment of the English High Court in Nigeria. The Lagos State High Court held the proper court with the subject matter jurisdiction to entertain an application for the recognition and enforcement of a foreign judgment is the court with the subject matter jurisdiction over the matter that gave rise to the foreign judgment. Unfortunately, I brought that application and lost it on the basis that the State High Court did not have jurisdiction. In that case, it was a matter that bordered about, the substantive dispute bordered about the breach of Dr. Erasmus Akimbola's duties as a director of the defunct Intercontinental Bank under Kama. And the Justice Candide Johnson reasoned that the matter could have gone to the Federal High Court because it arose from the operation of Kama if the substantive case was litigated in Nigeria. So by parity of reason, I think that the decision of Candide Johnson supports the decision of the Federal High Court, the registrar this case of Ikoyi that I mentioned, the registrar trustee of the Ikoyi Club that I mentioned. Thank you very much.
Thank you, Dr. Kweme. So I have one more question for Mrs. Adekoya. Mrs. Adekoya, Leneso, based on your experience in investment disputes, I want to ask you about ICSID. On page 34 of the book, the author writes about the ICSID Act, which provides that an ICSID award shall be enforced in Nigeria as if it were an award contained in a final judgment of the Supreme Court, if a copy of such an award is duly certified by the Secretary General of the Center and filed at the Supreme Court. Is it plausible that apart from the courts, another mechanism should be considered for enforcing arbitral awards? Either the awards be enforceable as judgments of the Supreme Court like the ICSID awards, or specialized courts be established for enforcing these awards? Mr. Adekoya, you're muted.
Hello. I'd like to start by giving the basis for why ICSID awards are enforced in the manner in which they are. And in essence, it's because ICSID awards are results or judgments of disputes between a foreign investor and a state entity or a state. And to ensure that there is a speedy resolution of the disputes, the idea was mooted and accepted by all that for an ICSID award, it went straight to the Supreme Court. So no further appeal. Now, having said this, I need to also indicate that it is actually a two-step process because after an award is issued by ICSID, there is an annulment procedure where it is actually possible for the unsuccessful party to go back to ICSID and ask ICSID to annul that award. And a new panel, not appointed by the parties, is set up to review that ICSID award on extremely limited grounds. The grounds upon which an ICSID award can be set aside are even more limited than the grounds that are listed either in the Arbitration and Conciliation Act or even in the New York Convention. Now, if the annulment committee upholds the decision, the award, or there is no request to the annulment committee, then the enforcement procedure takes place. So the enforcement procedure actually has allowed for some sort of an appellate or a review process. Once it's applied to the Supreme Court in country, and the reason why it goes straight to the Supreme Court is the thought that the enforcement mechanisms anywhere are under the authority of the state. And therefore, to ensure that there is as little delay as possible, ICSID says an ICSID award goes straight to the Supreme Court of the state, the highest court of the state, and is enforced as a judgment of the highest court. So there's no further appeal. For commercial arbitration, we do not have that process. It is a process that once you've got your award, you either seek to set it aside or you seek to enforce it. And therefore, there must be some means of allowing a review of the award on the basis of the limited provisions. But because for commercial arbitration, there's no enforcement mechanism, unlike in ICSID, where there is the Supreme Court, and if the state court then upholds the, once it's registered by the Supreme Court, if the state entity does not pay, then the World Bank has its own internal pressure mechanisms for ensuring that the country complies. So for instance, if there are World Bank projects and there are funds that need to be paid to that country, and that country has outstanding ICSID awards that they have not paid, then there's diplomatic pressure behind the scenes to ensure that compliance takes place. That scenario does not exist within the realm of commercial arbitration. Should we have specialized courts? I personally do not think so. I think that it is sufficient if we go through the same commercial courts for the setting aside of the enforcement procedures. But perhaps we could have some mechanisms. Perhaps we should have practice directions so that the provisions that apply to default judgments apply also to arbitration awards. For a default judgment, unless there's evidence of non-service or non-jurisdiction or fraud, you cannot set aside a default judgment once you have appeared, but you failed to file pleadings. Perhaps we should again have a look at training our judges to understand that to set aside or to enforce an arbitration award, it is on very limited grounds. And perhaps it might be a good idea to make Nigeria a showcase for international, make it more attractive, to then say enforcement procedures in arbitration will go on fast track. Having said that, I'm not sure whether the fast track, at least that we have in Lagos, is actually a fast track. But to speed that process through the courts so that the enforcement stage is not a full-blown litigation stage that commences after you've concluded your arbitration.
Thank you, Mrs. Adekoya. And thank you to the panel for
Deborah. Hello, Deborah.
Yes.
Just to ask the learned essay a further question to see if what our thought will be. We are aware today that most courts, including Lagos State, have added arbitration through the multi-door courthouse into their system. And my understanding is that rarely can the outcome of those judgments from the multi-door courthouse be overturned because they are more or less under the supervision of the judiciary. So I'm asking in respect to commercial arbitration, if that level, especially for foreign arbitration, if that kind of protection will not be provided, or that kind of preference, or that kind of, what I mean is guidance or sponsorship by the judiciary itself as a way of reducing the caseload, but making sure that once you pass through that process, you are not going to get out of the outcome of arbitration. Just to know how to. Thanks.
Well, my thoughts on that are philosophical. The first thing is arbitration is consensual.
Yeah.
And there must be an arbitration clause in writing. So if we go into court and the court then says go to the multi-door courthouse, the judge cannot force a party to go and arbitrate. You can force a party to mediate. And the concept of the multi-door courthouse is that a settlement by mediation will be signed and approved by both parties, and then will be entered as a judgment of the court. If parties have mediated and settled, we assume that actually there will be no requirement for enforcement. If you go into the multi-door courthouse, can I be forced to sign an arbitration agreement? Because there must be an arbitration agreement. Now let us even assume that I decide that, yes, let's try and arbitrate this dispute. And both parties then sign an arbitration clause, which now is the submission to arbitration. And we then have our arbitration under the auspices of the multi-door courthouse. I see no reason why you are thereby outside of, I still have to go back into court to set it aside or to enforce it. The fact that it went through the multi-door courthouse does not mean that it then becomes a judgment of the court. It's an arbitration, it's an award. There's a possibility that depending on who the arbitrators were, if I can show that the procedures of the arbitration were not complied with, the judge still would not enforce the award. So I'm not sure whether the multi-door courthouse route would make arbitration more stable.
Thank you, Mrs. Adekoya.
My views.
For that thoughts.
Madam Moderator, do you mind if I just say something?
Yes, sure, Dr. Kwame.
I think, Mrs. Adekoya, I think Mr. Weche is onto something. I agree totally with what you have said. But I think I have come across with
Mr. Adio, we can't hear you. Okay, Mr. Adio, we can't hear you. I think while we wait for Mr. Adio's connection to come back, can I please invite the panelists to share some war stories regarding the enforcement of arbitral awards and withhold the names of the parties since arbitration is confidential? Mrs. Ade.
I'm not going to share a war story. Okay, let me share a war story where it is not confidential because it's an ICSID arbitration. And it's something that I think we need to look at in terms of what could happen in Nigeria. This was the case of WRB Enterprises and Grenada. And I was one of the arbitrators. And the issue was a country had done a deregulation of its electricity supply. and had a 40-year license given out to the investor. At some point, the country then decided that perhaps the manner in which they had decoupled their electricity system was not in the best interest of the country. And they then brought legislation to change the structure. They cut down the amount of the number of years of the license. And in addition to that, they actually decoupled the license. So whereas initially the investor had a generating and a distribution license, they made them two separate licenses. Obviously, investor having paid so much for this privilege of being a monopoly supplier, the matter ended up before ICSID. And as I listened to the arguments on both sides, I kept on thinking of Nigeria and speculating that this is something that could happen, not just in Nigeria, but in any country that is deregulating an industry and the issues that we needed to be aware of. So anybody who's interested in privatization or deregulation or the power sector generally, I would say go online and look for that case, WRB Enterprises versus Government of Grenada.
Thank you, Mrs. Adekoya. Mr. Oweche, any stories or an interesting case you want to share?
The answer will be no, because I still work for my current employer. So I don't think the one I have is confidential, and I wouldn't share. The only thing I would like to say is that even though we're talking about arbitration here, I thought I went through a process where we went through that process, but it provided us an opportunity to reassess the issue, and then parties were able to achieve settlement based on that, which I thought was a win-win situation. So the fact that an award has been made, ipso facto, does not preclude parties from going back to say, look, can't we settle this matter and come to an agreement that is less than what the arbitral award was, but still enable both parties to walk away feeling the no victor, no vanquished mindset. So I think that's what I would like to say, that arbitration, it's arbitral awards, even after they are made, still does not preclude parties from reaching out, especially their business parties, and to still find a way to settle that. Although I'm sorry that, like Mr. Adekoya, I don't have too many war stories. Thank you.
Thank you, Mr. Oweche. Dr. Kweme, anything you would like to share with us?
Okay, I can share a story, relating to an enforcement of International Arbitral Award rendered sometime in 2018 by an IC tribunal in Switzerland. The relevant arbitration was between a Nigerian electricity distribution company and a Turkish power company. We represented the Nigerian company, which lost in the arbitration. And we resisted on behalf of the company the recognition and the enforcement of the award. On the ground that the award was against the public policy of Nigeria under section 52(2)B Roman figure 2 of the Arbitration and Conciliation Act. Now, we also filed an application to set aside the award on the same ground, but relying on section 48(B) Roman figure 2 of the same act. The gravamen of our challenge of the award was that the contract between the parties that gave rise to the award was for the transfer of a technological know-how by the Turkish company to the Nigerian company, and that the National Office for the Technology Acquisition and Promotion refused an application to register the contract that was subject to NOTAP approval under the NOTAP Act. And in the judgment, the High Court of the Federal Capital Territory set aside the award on the grounds that the NOTAP Act, the relevant provisions of the NOTAP Act are mandatory provisions of Nigerian law and applied to a contract for the transfer of technology that was an issue in that case. And that the award sought to be registered contravened the mandatory provision of the NOTAP Act because it would force a Nigerian company to make payments to the foreign entity pursuant to a contract that the NOTAP had refused to register. And in consequence thereof, the application to register and enforce the award was rejected. That's my short story.
Thank you, Dr. Kweme. Mr. Adu, I don't know if your mic your network is better, and if you have a case you would like to share with us.
Yeah, but my net, it was in the most inauspicious time that I lost connection. But yeah, if I had to go back to what I was just going to say before, based on the comment that Mr. Wechi had made and Mr. Adikoya's response, I was just thinking that perhaps Lagos, for example, and maybe there might be other sub-nationals, are also going in the direction of promoting arbitration. So, for example, to the extent Lagos State government and some of its agencies are now incorporating arbitration provisions in their agreements, albeit under the auspices of the multi-door courthouse. That could be another indication that, in fact, arbitration has really become fairly entrenched in our legal system, and that portends, a very bright future in terms of people resolving their disputes by arbitration. So, yes, that's going to say. Now, I didn't hear the question regarding war stories, but I can think of one, which is maybe not so much a war story, but a situation where I represented the respondent. And when we got the notice of arbitration, I had called counsel for the petitioner and said, who happened to be a friend, that I didn't think they had a case. I didn't even think they had a good case. I didn't think they had a case. And he responded that, Jamie, that's none of your business. You just file your response and what have you. And ultimately, we did that. After we did that, the other side now decided to withdraw from the proceedings. The proceedings hadn't commenced, but we had appointed our own arbitrator. A panel had been constituted. And then when they sought to discontinue proceedings, and the panel decided that, well, you can't request that a refund of the fees that they had paid. They now decided, because of that, to proceed with the arbitration. That in and of itself was very bad practice, but they now decided to proceed with the arbitration. Ultimately, they lost, and we filed a motion for attorney's fees and costs, which was ultimately granted by the panel. So that's something we haven't talked about. Actually, sometimes a winning party filing for attorney's fees and costs, and in this case, it was actually granted by the panel. And of course, what has happened is that the losing side has, they appealed for the award to be set aside, and we're still in court. I think the case is in the Supreme Court now, but because it's a civil case, so it probably won't see the light of day for many years to come.
Thank you, Mr. Dio. Mrs. Akeredolu, do you have any story for us?
Oh, yeah, I mean, well, war story regarding enforcement or recognition. Oh, I've had a number of skirmishes in the high courts in the course of trying to, between federal and state, well, more of federal high courts, between trying to either get the court to enforce or get the court to set aside. The moment the matter enters court, my observation is that all the shenanigans of litigation come into play, which is where I recommend Chinwe's book, where she talks about training for judges and for lawyers. And I'm happy with the directive of the immediate past Chief Justice of Nigeria, which says judges should honor arbitration agreements in matters that come before them. So my war stories in that regard were prior to the issuance of that directive. I am hoping that if we do the arbitration institutions and whatever organizations should, if we are able to engage training of judges to a larger extent and degree, so that they understand the value this will bring to foreign direct investment and investor confidence in the Nigerian system regarding dispute resolution. Because one of the first things an investor who wants to come in will ask you is, how long does it take for you a dispute to be determined? And it's such an embarrassing question because you know the truth. And you know, we're scratching our head, we're looking, if it's at a meeting, you're squirming in your seat, trying, I mean, you know you mustn't lie, ethically it's wrong. And you then try to paint a nasty picture in a nice way. So if judges were more aware of the reasons for arbitration, the role of arbitration, and the way it differs from litigation, perhaps they would adopt a different mindset and matters would be determined much faster. But like I said, my experience is the moment the award goes to court, either for enforcement or for setting aside, all the shenanigans of litigation kick in. Adjournment, what we just served yesterday, we're going to file tomorrow, and all of that. And it's pretty vexatious. So my one war story is the NNPC and IPCO arbitration. I was with Aluko Honorable and was part of the team, well, a strong part of the team that did that arbitration as counsel for IPCO. We were claimants in the arbitration. Up till a couple of years ago, it was one of the largest domestic arbitral awards this country had ever seen. I think our award was $150 million. And enforcement, most of the enforcement is offshore. The NNPC in the offshore is in the public domain, so I'm not breaching confidentiality. Sorry. They try to enforce in the UK. NNPC gets to the UK and says, no, they are proceedings in Nigeria. So the UK court says, okay, let's wait for some of the proceedings in Nigeria. And they waited forever. At some point, I guess the UK court had to say, look, your proceedings in Nigeria are going on forever. Okay, take 100 of this $150 million for a start. We are still in court in Nigeria. They are still in courts in Nigeria. You know, even government and government agencies need to realize that in the process of trying to save yourself at all costs, no matter whose ox is gored, we are doing damage to the larger public. We need to have more of a sense of commonwealth, not only in arbitration, in our general living. Sorry, this is not a philosophical treatise, so I shall rest my case there. Thank you.
Thank you, Mrs. Akeredolu. Mr. Bosari, are you still with us? I don't know if you have any case or story you want to share with us. Okay, so I think we can close this panel, but I would ask respectfully each of the panelists to just give a recommended change that will ensure that Nigeria is more arbitration friendly. Can we start with Mrs. Adekoya?
My recommended change is that where you are seeking to enforce enforce, and this is not just for arbitration, I would do it for anything, where you're seeking to enforce an award and the other party is seeking to set it aside, because of the limited grounds upon which arbitration awards can be set aside, I would make the provision of a bank guarantee for the amount of the award a precondition for the setting aside application to even be listed for hearing. So if you're very sure that that award is wrong, you should have no problems with putting up a bank guarantee, knowing that you'll get your money back with the interest that has accrued on it, either with an agreed escrow agent who would then hand over the proceeds when the setting aside application is concluded. That would be my one practice direction or requirement that could give some speed to the process. If the party is not sure, you won't put down your bank guarantee. So your award, your setting aside application will lapse, and the party seeking enforcement can go ahead and apply for enforcement. If you have a strong case, you put up that bank guarantee. And if you're just playing shenanigans against time because of the time value of money, if you've had to put that money down, at the end of the day, the issue of time value of money would have been taken care of. So that would be my suggestion.
Excellent. Thank you, Mrs. Adekoya. I've definitely taken that down myself. Mr. Oweche, can we hear from you now?
Thank you, Deborah. A lot has been said. We had this issue of unacceptable delays in adjudication in Nigeria. And we saw it very terrible in the area of elections, where a governor can be seated there in the state and he's in having election petition 2 years, 3 years, and then the election tribunal will hold is no longer the governor, but then he has been there for 3 years. So we solved it by making sure that clear timelines are set, and as well as issues that should not go before electoral petition tribunal. I think it's part of the suggestion by Mr. Adekoya. I think we need to get the court to issue clear practice guidelines, saying clearly that these are the time frame for certain things to be done, and to hold to it very strictly, so that you can achieve that certainty of resolution of dispute and its enforcement, which is one of the key attractions of arbitration. I think if we do that, it will meet the antics of those who want to keep that process ongoing till thy kingdom come. That will be my suggestion.
Thank you, Mr. Oweche. Dr. Ekweme.
Well, I mean, let me start by saying that I don't disagree with Mr. Adekoya is saying regarding the recommendation for bank guarantee before an application for setting aside of an award is had. But an alternative option, could be that a consolidation of the two applications. That is to say that the court will schedule the hearing of the application to set aside together with that application to recognize and enforce the award. And then write a judgment that will first of all deal with the application for setting aside. So that if the application fails, then the court will deliver judgment on the application for enforcement of the award. And that will forestall the concern raised by Mr. Adekoya, regarding a party that wants to appeal the decision on setting aside and apply for stay of the application for recognition and enforcement. Now, the other suggestion that I would like to make is a attitudinal change. of lawyers. I see that because the litigators are also the arbitrators. So we take our litigation adversarial mindset into arbitration. We don't want to lose. So we challenge an award even when there is no, cognizable basis for challenging the award. In all the arbitrations that I did, concluded, all ended in courts, all. I mean, there is just one now. It's just the award is young. I am expecting that an application to set aside will come. Now, the other problem that I see in arbitration is in Nigeria is the confusion in the Federal High Court. The jurisprudence of the Federal High Court is in a state of flux regarding the power of the Federal High Court to grant an injunction in aid of arbitration. I think that there should be clarification of that power, expressly in the Arbitration and Conciliation Act. I think the provision is in the Arbitration and Conciliation Amendment Bill. Hopefully, the House of Representatives will pass that bill. And I'll build on a point that Mr. Dekoya and Mr. Weche made earlier, which is on the education of our judges regarding, the role of courts in relation to arbitration, especially on recognition and the enforcement of arbitral awards and setting aside. You see, there is this confusion as to, the proper role of our courts. A setting aside application is not an appeal on the merits. A setting aside application is an invitation to the courts to challenge the decision-making process of the arbitrator on certain limited grounds, recognized in the law. Now, an appeal is really, an invitation to the courts to review the case on the merits, both on the merits and the decision-making process. So if our courts recognize that, it is not both, rather that it is one, the decision-making process of the arbitrator along the lines of the stipulation in the enabling law, I think it will be helpful. Thank you very much.
Thank you very much, Dr. Ekweme. Well said. Mrs. Akeredolu. Hello, Mrs. Akeredolu.
Hello, yes.
Okay. Can you give us one recommended change as we end?
Well, I mean, before I heard Mrs. Adekoya's suggestion, Mrs. Adekoya SAN's suggestion, what I had in mind and discussed and tried to use as a strategy in matters like this is to bring an application for security for costs before the hearing of such an application. But then after listening to Mrs. Adekoya SAN, I recognized that once a ruling is given on the application for security for costs, you have a subject matter for appeal. So you deviate from the main subject and you chase that one all the way up to the Supreme Court, which is why Mrs. Adekoya's SAN suggestion is good. But maybe now I'm still wearing my litigator's cap. So if that is going to come by way of practice direction, my question, which I haven't resolved in my mind, but what does agitate my mind in that regard is, are we not fettering the right of a person to apply to set aside an award? It's a question. I am happy for because by the time you are telling a client who says, set aside this award, set aside this award, you're telling them, well, okay, you have to provide a bank guarantee. He will adjust himself. But then, is it not a fetter on the provisions of the Constitution, the right to, which we need to think about? Because a party who does not like that idea will definitely raise the right that you are question and the issue that you are fettering their right. And if that came by way of practice direction, the question would then be, as a sort of subsidiary legislation, is it not overriding the substantive law? And bigger question, the Constitution. So those are questions that we need to look at in propounding this either as a practice direction or rules of court or whatever. I had a case where the same award, the defendant who didn't want it enforced went to the Federal High Court. We, in trying to enforce, went to the State High Court. I'm talking here about the issue of consolidation. So in the Federal High Court, where the other side went, we brought a plenary objection that the Federal High Court didn't have jurisdiction, and we were driving our enforcement in the State High Court. So to consolidate, except it is struck out based on our preliminary objection in the Federal High Court, there'll be very little scope for consolidation. But like I said, when I started my submissions, the moment the matter goes to court at the enforcement or refusal to enforce stage, the litigation mindset and all its shenanigans kick in. So we need to limit the scope. I think that's the first thing we need to look at. Limit the scope of what you can go to ask, the reasons why you can ask a court to set aside an award. That needs to be limited. Thank you.
Thank you, Mrs. Akeredolu. Mr. Adio, any recommendations from you?
Yes, thank you, Deborah. First, I will take on where Dr. KUK left off, which is the issue of the attitudinal change. Because I think that at the end of the day, with practice directions, rules of court, et cetera, if we don't have that attitudinal change, which I mentioned in my address, then it's still the same practitioners are going to be applying these practice directions and rules of court. So I think that mindset is that change in mindset is very, very significant. That's number one. Number two, we've talked about, for the most part, the what's, if I may use that description in terms of arbitration practice in Nigeria, but there's some silver linings as well, and I can give you one example. One example would be that I've had that experience where parties have gone to arbitration, and in the course of the proceedings, you encounter legal counsel that is very reasonable, and ultimately advises its clients that we ought to settle, and then a consent award is ultimately entered. And then you have something concrete to hold on to. And in the experience that I have, my client, who was the petitioner, was really hamstrung, and even the ability to have paid the full fees of the panel would have been a challenge. They would have paid it ultimately, but it would have been a challenge. And I think opposing counsel even knew this. But in spite of that, he agreed on the merits that we had a very good case. And ultimately, the case was resolved. And not only was it resolved, as part of the resolution, the balance payment that we ought to make to the panel was deducted from the amount ultimately transferred to my client. I thought that was very exemplary of Mr. Mike Igbokwe. He was the counsel on the other side, to give an example. So I think, as practitioners, there's some silver linings, and there's some that actually do engage in very good practice, because just because you're an arbitrator doesn't mean ultimately still come to a resolution. I'll end by saying that one knotty issue that I haven't thought it through, has to do with oftentimes, even though parties have entered into an arbitration agreement, people still run into court to try and litigate that same case. When the defendant now brings an objection that we ought to be in arbitration, and the court finds that, yes, you ought to be in arbitration,
I think we've lost Mr. Adio. I think we've lost Mr. Adio. Okay.
Sorry?
Can I hear you?
Yes,
No,
sorry. Okay, I was just saying that, oftentimes, on the case, it's clear on the face of a document that the party should be in arbitration, and oftentimes practitioners still run into court. And when an objection is brought and the court sustains the objection that yes, you ought to be in arbitration, counsel will still appeal that decision just because you don't want to go to arbitration. It's very, very bad practice. So I think that there should be heavy sanctions when it's clear that you ought to be in arbitration as opposed to coming into court. If you're coming to court for interim relief for preservatory orders, perhaps, but not to try and insist that on some very, not even attenuated, it's clear that you ought to be in arbitration, you still try to find a way to stay in court. I think significant, substantial penalties should be imposed on parties that engage in that kind of conduct. Thank you.
Thank you, Mr. Dio, and thank you everyone for your contributions. Well, we have one question from Rotimi Odushola. Rotimi, can you make your question short, please?
Yes, thank you very much. I'm very pleased to be here. I'm going to try as much as possible to make it brief. There's, in the context of what we're discussing around, what could be suggestions for change that might make the whole process of arbitration and the enforcement of arbitral awards more effective and less painful for the parties. I'd like to ask any of the panelists, this is something that's agitated my mind. I've spoken to someone on this call, Diane Okoko, about this in the past. Is it the practice? And if it is not, is it something you would recommend that parties to an arbitral agreement, in the arbitration agreement itself, in addition to agreeing to go to arbitration, should also agree that any subsequent proceedings in court that has to do either with enforcement or with setting aside or whatever shall start and end only with the High Court and will not be a subject of subsequent appeals beyond the High Court or beyond the court that has the power to make that decision. And the reason why I ask this question is, maybe it's a way of saying we're elevating the enforcement of arbitral awards to the same level as what you have with, judgments that are, entered in litigation by consent of parties. Remember, parties consented to go into arbitration. Now, it would appear that if we don't do something like that, this is my view, we might just be giving the losing party who has the intention of stringing the other party along just another layer of the entire litigation, process. So that's my question. I'm not sure whether it's something that parties do, and if they can do it. I mean, you can say it's a circumscription of the rights of the parties, but if they go into it voluntarily, would that not be something that helps the process?
Well, I mean, should I go first? Well, my reaction to your question is to say that, I mean, that would be a novel provision. I agree with you that arbitration is consensual and the consent of the parties, should drive arbitration. But I don't, I cannot assert without fear of contradiction, that the consent of the parties should also, govern the right of access to courts. Because what you're saying is that the agreement will be a right to waive, the right of appeal. Although I gathered, I mean, when I was discussing a case that I did, the case of FRN and Adigwe, and against the FRN versus Adigwe. In that case, it was about to appeal within extension of time to appeal a decision bordering on jurisdiction. I mean, the Supreme Court held that there was no good reason provided, but because it was jurisdiction, that they would, grant leave. And someone told me just about 2 weeks ago that the Supreme Court now said in another case that I've not seen, that the right of appeal can be waived. And if I see the case and confirm it, then it will mean that your proposal is doable, it will be enforceable. If there is that Supreme Court decision that says that a right of appeal can be waived. But other cases that I know stand for the proposition that a right of appeal is constitutional. So I need to see the latest case of the Supreme Court on that point. And if I see it, I can share it with you. And if I have it, then my answer will be to arbitrate can be enforceable, will be enforceable. Thank you.
If I may, provide a response to MRU's, Mr. Rotimi Odishola's question. What you propose, extremely laudable, but would only be properly workable in an ideal jurisdiction. If I had a client to which your suggestion was proposed, my immediate worry would be, and Nigerians as a jurisdiction, we are very creative in our thinking. To sign up to an agreement like this, first and foremost, I would want to know who counsel on the other side will be. And then I will immediately think, which court are we going to be? Which court will be the high court that we have pegged, to which we have pegged this agreement? Is it this federal high court I'm looking at here in Lagos? I will not allow my client to sign up to it. I will leave it at that. Mr. Adio, I see him laughing. Chinwe is smiling. Even you, Rotimi Odishola, you have practiced in this jurisdiction, you are laughing. I will leave it at that. Great suggestion, but only in a jurisdiction where you can vouch for the high court that will be making that determination. My suggestion of achieving what?
It will be an agreement against public policy. It will be struck down.
my suggestion for dealing with this issue, achieving what you seek to achieve, is to put it in legislation and say, and which I had said earlier, limit the scope. Because we need to be mindful of constitutional provisions that say you must be able to articulate your civil rights and Section 6 of the Constitution. We need to be mindful of that. So the way to put it in legislation is to say, rough sketch. Where you have an arbitral award, you can only for certain reasons limit the scope. And then even if you then ventilate those reasons in court, you can't go beyond perhaps the Court of Appeal. Because like Chinwe's book identifies the issue of corruption. If you can put one judge of the High Court in your pocket, it is harder for you to put 3 justices of the Court of Appeal in your pocket. And I would stop it at the Court of Appeal, because don't forget, an arbitrator, a sole arbitrator, or a tribunal of 3 arbitrators have come to a decision. A judge of the High Court has decided, yes, you can enforce or you can't enforce. And 3 justices of the Court of Appeal have also looked at it. It's okay now. That would be my suggestion for achieving what you seek to achieve. But it's very dangerous I wouldn't, for instance, allow my clients to commit to saying, we can only take an award to the High Court after High Court is over. And people are very creative.
Deborah, not to usurp your role, but I don't know whether you want to put this question to the panel. Somebody in the audience has asked the question that, is there anyone on the panel that, having lost an arbitration proceedings, did not seek a setting aside of the award? Anyone on the panel?
Yes.
Madam Moderator, please. We have just 2 minutes, 2 more minutes. Madam Moderator, thank you very much. 2 more minutes, please.
Okay, thank you. Mr. Dio, I saw that question. I saw that question, and I know Farouk, so I know he knows the answer to that question. So, can I say
He directed the questions to the learned field.
yes, he knows. He knows that.
Deborah, thank you for the protection. Thank you for the protection.
You're welcome, sir. So thank you very much to all of our panelists for such an enlightening discussion. Thank you to our attendees. I'll be handing over back to Wale now. Thank you.
We have been saved by the bell.
Yes.
Thank you very much.
The only disappointment is that Edolu did not speak to us in Italian, French, or German.
Mr. Dio should go and ask how much is paid for translation per page.
Okay, then. Thank you very much, distinguished members of the panel. We really want to appreciate you for that session. That was beautifully put together and, of course, moderated by our own Debbie. Thank you very much once again. So right about now, ladies and gentlemen, I give you in writing that would be finishing in about 15 minutes. If you give us that extra time, sort of. So right about now, I'll be introducing us to the world of the woman of the day, the one that I choose to call the celebrant, the arbitrator, the wife, the mother, the hard worker, the brilliant lawyer, the dedicated achiever, and now the author. Ladies and gentlemen, please permit me to introduce Mrs. Chinwe Odigwegu. She is the Senior Commercial Legal Manager of Guinness Nigeria PLC. She is also the Secretary of Guinness Nigeria's Diversity and Inclusion Board and a member of the steering committee of the company's Spirited Women's Network. She is a legal practitioner, notary public for Nigeria, fellow of the Chartered Institute of Arbitrators, accredited mediator of the Center for Effective Dispute Resolution UK, and certified trainer in mediation and negotiation of the Bond University of Australia. Mrs. Odigwegu is a member of the Nigerian Bar Association, International Bar Association, the panel of neutrals of the Lagos Court of Arbitration, panel of neutrals and training faculty of the Lagos Multi-Law Court House. She is also a training faculty member of the Negotiation and Conflict Management Group and the Standing Conference of Mediation Advocates UK. Ladies and gentlemen, our celebrant of today, prior to joining Guinness Nigeria PLC, hear me, please?
Yes, we can hear you now.
So sorry about the break in transmission. Obviously, it was simply because
I think we've lost Wale. Chinwe, he was introducing you.
Wale didn't feed his enemies this morning.
no.
Oh my.
Okay, he's back.
Apologies for that, ladies and gentlemen, distinguished guests. That was, of course, one of those things that you see when you are online, for more than the allotted time. So ordinarily, this event should have closed at 11 o'clock. But of course, for obvious reasons, and one of which will probably be the fact that we've been enjoying these sessions, we had to exceed beyond that time. So sorry for that. Apologies once again. In closing on the introduction, ladies and gentlemen, Mrs. Odigwegu is a natural teacher and a creative writer, one who enjoys singing and is passionate about youth development. She is a recipient of many prestigious awards, including the ESQ Nigerian Legal Awards, Top 40 Lawyers Under 40, and Coca-Cola Hellenic Extra Mile Lawyer Award, to mention but a few. Ladies and gentlemen, please join me as I make welcome for the far side chart, which would be moderated by Debbie, of course. Ladies and gentlemen, please make welcome the author of today and the celebrant, Mrs. Chinwe Odigwe. Over to you now, Debbie.
Thank you. Thank you. Debbie, permit me to thank all our panelists, the good messages, book review, and the discussions. I feel so humbled. You know, Mrs. Adekoya, SAN, she had to drop off to join another session. Mr. Tunde Busari, SAN. Mrs. Abimbola Akeredolu, SAN. Mr. Sheni Adio, SAN. Dr. KUK Ekweme, who I call Dr. Crew. Mr. Uche Wecha, aka Prof, in-house counsel, we call him Prof. Mr. Rotimi Ojushola, my boss at Guinness, Nigeria. Ms. Deborah Chukwuedo, our able moderator. Wale Oshunde, our compare. And also for the firm that helped me to organize this long brand box, Theodora Kio Lawson and Okibu. So thank you very much. And I'm really grateful for all those who have joined this session. And this fireside chat, I hope we can cut it really short. Deborah knows I don't really like attention, but she wants us to have this. So we'll just cut it short. Thank you very much. Okay, Deborah, Chinwe, what do you want to ask me?
Let me just, I will make it as short as possible, but you can't dodge this one. Once you write a book, you belong to the public domain. So please, can you tell us what inspired you to write the book? We know lawyers draft every day, transactions, processes, briefs. What inspired you to write this book, and what did you learn from writing the book that was different from writing a legal process?
Okay, so actually this book, I wrote this between 2016 and 2017, and then I updated it this year. Okay, this was what inspired me to write it was I had to do my master's in law, international business law. Now I had done this just as I left Bamani Godalo and went in-house to be head of litigation and dispute resolution at Nigerian Bottling Company. Now, what inspired me to pick this topic was my experience over the years. So I have my own war stories from enforcement of arbitration, and there's no time to tell, but you know, from experience working in the disputes resolution practice group at BNI, going in-house to NBC and seeing everything, you know, thankfully at BNI, there's this thing about, you know, developing commercial acumen and understanding the client's business. So going in-house, you know, flowing in-house wasn't so difficult for me because, you know, I've been developing that mindset, knowing that when you're handling dispute or when you're handling any legal matter at all, the interest of the client or the interest of the company should be topmost. And it's about what can impact on a business, what risks can be created when things happen. So to the topic, you know, I wanted to narrow it down to international arbitration and narrow it down to where a Nigerian party is the losing party and then the enforcement is supposed to be done in Nigeria. What made me do that was my experience, you know, the year before I started this research, you know, I only have two success stories from arbitration. Like Dr. Crew, almost every arbitration, you know, has ended up in courts. But these two, the first one was an international award to be enforced against a Nigerian party. How did we successfully enforce it? Was that we went ex parte to the Federal High Court and got the award. And part of what we prayed for was for the accounts of the award debtor to be frozen. And that was the only way we could get them. So all the accounts are frozen. This was at the end of the year. And to the issue around corruption of judges, I don't want to mention the name of the Federal High Court judge, but years later, this judge was indicted for corruption. He had given this ex parte order, and then days later, when the award debtor was put on notice, in open court, I knew they had gone to see him in chambers. I was very sure about that. I didn't have any evidence, but I was very sure. Because in court there, he was stuttering. I was saying, Mrs. Odigwegu, should I have even granted this ex parte? Shouldn't you have put them on notice? And I pointed, I said, see the rules of court, see the provisions under which I brought the application. And clearly he was stuttering. I could see counsel from that side and SAN and some other people from the law firm. You know, they came in with some kind of confidence, like, you know, they were good. And I was like, what is going on here? Do you know, he was about to, I stood up, and then, you know, counsel was saying, I'm on my feet. I said, I'm on my feet too. I was on my feet first. It was a battle, you know, and in the end, because it was open court, what was the ground on which they said the award shouldn't have been given? They said by freezing the accounts, they were not able to pay salaries, and they brought up the issues around human rights and blah, 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 and how people will suffer. And what we agreed, you know, before we went to court, you know, back in the firm, was that we would say to the court, let the other party bring an affidavit deposing to how much salaries would be, because all their accounts were frozen. Nigerian, their dollar accounts, their euro account, their pounds account. Come and show the court how much you want to pay salaries, how many staff you have. And, you know, on that basis, we were able to reap the fruits of that award, right? But in the end, we settled because we now, our client now agreed to let go of the interest element of the award. But I saw all that drama. I'm like, okay, there's something to look into here. So that experience and some other experiences made me choose this topic. And to be honest, you know, what Mr. Busari has said, Mr. Akeredolu, you know, those who have read the book will tell you that I've made some bold statements. They're very short statements here and there, which ideally people will not want to say. It's like I'm shaking tables, kind of, because I feel these are things we need to address. And with all respect, I hope that you know, the recommendations will be taken and we'll start to see changes, because it's a combination of so many things. Okay, so I hope I've answered the question as to why I chose the topic. It had to do with my war stories and the experience and my passion for change, actually, without going into politics.
Definitely. Thank you, Chinwe. So just one more question, because I know your work schedule, I don't want to, you know, start naming the many hats that you wear, but as well as being a lawyer, mediator, arbitrator, and all of that, when did you find the time to write this book? You just said you wrote it when you were transferring your money. So how did you find the time to write this book while doing all of that?
Okay, so thank you, Debbie. So I must thank my employers, my former employers, Coca-Cola Hellenic, because I had to take out time, and of course my family, my husband released me. I had to travel to the UK like 2-3 times during that LLM study. So I got extended leave and flexible work. So I was working from the UK while doing my master's, you know, and somehow the hours were flexible. It took a lot of working at night, actually. It was stressful, but the fact that I was able to be away to, you know, do the research and study. So that's how I was able to do it. It took a period of not up to a year, but quite a number of long hours and all that, because there were times I had to do lectures, I had to do my coursework and then write the thesis. So yeah, I took out time, you know, from work. I had my full leave. So it was from end of one year to another year. So full leave for the end of a particular year, full leave for the subsequent year. And I was able to write it. You know, it was a lot of research and all that. And I just thank God I was able to do it anyway. Thank you.
Thank you, Chinwe. I think you've been saved by time. So I will hand over back to Wale. Thank you for sharing.
Thank you, Debbie. Thank you, everyone.
Thank you very much, Mrs. Chukwedo, for that one. That was so beautiful. Thank you so much, the author as well. Thank you very much for keeping it simple, short, and of course, straight to the point. Thank you very much for that. Congratulations once again. So staying with you, ladies and gentlemen, it gives me great pleasure to at least present the very first copy of the book that we are all talking about and celebrating today. And of course, we'll be inviting our author to at least say something about the book and then sign the very first copy. Well, that would then launch us straight into the launching. Thank you, author. Please, over to you.
Thank you. So let me just quickly say. So Nigeria is a great country. We always have issues. So these books, I've been waiting for them for quite a number of weeks, and I just got them this morning. So that's why panelists don't have their copies in their hands. But I thank God I'm holding the book right now. Let me just read the last paragraph of the book, the very last paragraph, okay? So I said, Nigeria may not be ranked as a top arbitration-friendly country at this time due to the current position of enforcement of foreign awards, but certainly cannot be described as one that is anti-arbitration. The challenges, though fundamental, are not unsurmountable. What is required of the government and other stakeholders identified and is already in view is a radical change in attitude, followed by bold and proactive demonstration of the willpower to do what is required to change Nigeria's reputation internationally in this regard. And on that basis, I present to you my book. It's a long title, but very, very important. Foreign International Commercial Arbitration Awards, Recognition and Enforcement, the Nigerian Situation, Challenges and Proposed Solutions. Thank you very much. So Wale says I should sign it. I'll just open the first page and put my signature. Thank you very much. And here you go.
So please show us the signature. Please show us the signature on the very first page. Thank you. So that evidences it, and then I'm sure we're all clapping for you at this time. Congratulations! Congratulations!
Thank you very much. I'm so humble.
Congratulations!
Thank you. And thank you to all those who have got the book. Some people already ordered and will be receiving their copies in a few days. Thank you very much.
Okay then. So at this time, I would be encouraging everybody with all this strength in me to please reach out to the author and of course order their own copies, at least one copy per person. Please reach out to the author right after this event and order for as many copies as possible. Please send some copies to your friends, to your colleagues at work, to law students, to law faculties, to everybody that you know would, of course, be impacted and, of course, influenced by the contents thereof. Thank you very much, everyone. Congratulations once again to the author. So, right about now, ladies and gentlemen, in closing this event, I have the singular honor of inviting one very important and distinguished personality to please talk to us. Ladies and gentlemen, I have the singular honor of introducing, first of all, Mr. Rotimi Odushola. He is the legal director and company secretary, and of course, he's had over 2 decades of leadership experience in board multifunctional roles, spanning legal practice, corporate and regulatory affairs, as well as commercial legal management. He joined Guinness Nigeria as a legal director in November 2014, and prior to that, he was Senior Manager, Commercial Legal in MTN Nigeria Communications Limited. At MTN, he was responsible for providing proactive legal advice and support to the various units of the multinational communication business in Nigeria. Ladies and gentlemen, prior to joining MTN, it's my pleasure to say that Mr. Rotimi Odushola was Senior Manager at Aluko and Oyebode, one of Nigeria's leading commercial law firms, where he was responsible for full legal advisory services to major clients across various industries that included manufacturing, tobacco, agro-allied, and food processing, oil and gas, telecommunications, aviation, and banking. He was appointed the company secretary of Guinness Nigeria PLC with January 2016. Ladies and gentlemen, it gives me great pleasure to welcome, for his goodwill message and closing remarks, Mr. Rotimi Odushola. You have the floor now, sir.
Thank you very much, Wale. And I have to start by saying that I had intended to, make a very long speech today, but I'm going to save us, that trouble. I'm so pleased to be here. The first thing I want to say is that I have the, the request of the MD and CEO of Guinness Nigeria PLC, Mr. Bika Magunda, to first and foremost congratulate Chinwe, and also to thank everyone that's been a part of this. We've had the rare privilege of a distinguished panel. Really, really distinguished. And I personally consider this to be an opportunity for, for an X-ray of the state of arbitration in Nigeria. And that has been catalyzed by the remarkable work that Chinwe has done. And for that, again, we really, really are pleased and we're happy for you, Chinwe. We congratulate you. Chinwe is an invaluable member of the Guinness Nigeria and Diageo business in Nigeria. I mean, this, is something that I know that a lot of my colleagues were on the call and are still on the call, even across the shores of Nigeria. The legal community in Diageo worldwide is very, very proud of you, Chinwe, and would like to say that, publicly, because we appreciate what you brought. And, while he's spoken about a lot of the many parts that Chinwe has, in Guinness Nigeria, we consider Chinwe a leader in our business, one that, is not just a lawyer. I mean, she's a go-to person in the organization. And that is really, it's a remarkable thing for someone who has so many parts. I would also like to thank Mrs. Akeredolu, the learned SAN. I asked her earlier on the chat whether she sent her daughter to represent her on this call because she was looking so very young. So thank you very much for a very, very candid review of the book. If anyone on the call was not sure about whether the book was, a worthwhile read, I think after that review, we will be in no doubt at all. And then, I want to say for myself and to Chinwe publicly, I'm personally very proud to work with you as a colleague. It's been very, very, it's been a very remarkable and enjoyable, professional relationship. And I want to say I wasn't too surprised when I, learned that you are writing a book, because I know that you have that, multiple, capacity. So big congratulations on this milestone achievement. Today is also another milestone for you. I wish you, all of what you wish for yourself. Great message of goodwill from everyone in the Guinness, family. And I want to end, I know we don't have a lot of time. I want to end on the note that, please, if anybody has not ordered for this book, please, I am inviting you specially to please order your copies, and I'm sure that the review has done justice to it and the justification for us to want to have a part of the book. So thank you very much. I know that for many things that we know Chinwe to be, in the organization, we now know her also to be a successful author. And we say big congratulations. Thanks to everyone who has been part of this.
All right.
Thank you
very much, sir, for that excellent delivery. Thank you very much for that excellent delivery. We want to thank you very much. Your Excellencies, your Lordships, learned Silks, distinguished guests, it would be unfair if we close this event without celebrating this amazing personality, this positive mentor, this friend of great and invaluable value, and an intellectual powerhouse of our time, by singing a happy birthday song. I think we all need to put on our microphones if we are able to do that. And then at the count of 3, then we can all sing a happy birthday song for the celebrant. Okay, please, can we all put on our microphones?
Wale, which version? The standard version or the local version?
Mrs. Akeredolu will be singing in German.
Oh,
sorry, I got bounced off. I missed a lot of what MRO was saying.
Yeah, that you'll be singing in German or Italian.
You want to hear me? I can sing for you in German.
Okay, Grace.
Oh, you have
English.
to pay. Okay. You have to pay.
Thank you very much. So please, can we all put on our microphones? Can we please unmute ourselves? And at the count of three, we shall all be singing Happy Birthday song. You know that popular song that we all sing for our children and everyone that we love. So we'll be singing it. We'll be singing it for children. All right. So 1, 2. Thank you. I beg your pardon. So 1, 2, 3.
Happy birthday to you.
Happy
Happy birthday to you. Happy birthday, dear children.
Happy birthday
to you. We don't need to ask. You are 40 already. Congratulations.
Yeah, congratulations. I thank
Thank you
you
very
for the
much.
part of this August occasion.
Thank you.
Yeah,
And this
yeah.
is from my
Thank you.
legal team, my team in Guinness,
Ooh.
Nigeria. My boss just knows how to wow people. So legal team of Guinness, Nigeria. Thank
Wow.
you for the cake. Thank you.
I'm
That's very
jealous. So
good.
MRO, I'm 42 now.
Thank you. I'm so
Mrs.
grateful.
Akeredolu, when you are 21, when you become 21, we will do something.
I'll try.
Okay, then. Thank you very much.
Thank you, guys.
Your Excellencies, Your Lordships, learned
Thank
stewards,
you.
distinguished guests, ladies and gentlemen, thank you very much for being a part of this event. We really want to appreciate you on behalf of the author and celebrant and our sister and all the organizers of this event, those who have participated, members of the panel, the moderator, and everybody working behind the scenes. We want to really thank everyone for making our time to be a part of this very important event, very auspicious occasion. Thank you very much once again. I would now like to invite the celebrants to just say, our closing to thank all of us, and then we can then close. Thank you very much once again.
Thank you. So because of time, I've called everyone's name and I just have 2 words. Thank you. Thank you. Thank you. I'm so grateful. Thank you. Bye, everyone. Thank you for joining. Thank
Bye-bye.
you. Bye.
Bye.
Sorry, where is that compliment? Where is the compliment?
Are you still here?
I am, I just noticed there's still some participants. I'm just
okay.
Why don't you just log off and then speak offline?
No worries. So we'll end the webinar now.
Thank you so much.